G'day, Kim.
Hi, Andrew.
My reluctant visitor. You're back. And look at this. She's clinging to the script. We're going to have a bit of fun today. We've got a number of our clients. No, we are. We're going to talk about something you know nothing about, and we'll go, gee, I didn't know that was on here. We're going to talk about enterprise agreements negotiation as our main topic, mainly because about 50% of our clients' EAs expire on 30 June. And they should have done something, and some of them haven't. So I thought I would talk about that. I also want to talk about when we're dealing with psychological hazards, which is such a prevalent conversation, and storytelling is such a useful device to link people in. But I guess over the last 2 months, I've now sat at various venues where people have told stories, and some of them very traumatic stories. Some explicitly about violence they've suffered, some about virtual trauma they've had, some about child issues that they've had. And there's a few comments I want to make about it. One is, when people do this, they actually feel that it actually is helping them. And for some people, it genuinely does help. The evidence is that people who speak about trauma on a repeated basis don't heal well from trauma and inclined to be re-traumatized, although they desensitize themselves to a level. The loneliness of what happens afterwards is not good. So it's a dangerous thing to commence without good advice supporting you to do it, one. But two, you actually don't know your audience. And so,
a good point.
So the trauma you were talking about may be real trauma for someone else in that audience. And you notice how careful we are when we talk about cases, what we don't describe in cases, for that very reason. So I don't want to stop storytelling. I think it's a great thing. I don't want to stop storytelling in psychological hazards. I want there to be truth out there. What I want people to recognise is sometimes when we're inviting someone to do it, they do it because they feel like it's a great idea. And some people almost become a cause célèbre in their area of what bad has happened to them. They can live with that, and that can be good, and they can do great things with it. But the evidence is overwhelming that the repeated exposure and discussion of the trauma they've suffered actually harms them more. Not a great idea. But the thing they don't know about is the people who are sitting out there who are being re-traumatized as you speak. And, trigger warning aside, there is a need for real caution. Even when you say, look, we will be discussing this, that person has to get up out of the room and leave, and is self-identified by it. So can I just suggest as an idea, exercise some caution? I've heard some great examples of it being done very well, and I've seen some real Dr. Phil exercises which were pretty awful, tawdry, and left me feeling shockingly uncomfortable. So remember, it sounds like a good thing to tell a story of a terrible thing, and I think we've all had friends who've gone through difficult divorces who, over 5 glasses of wine, tell you how bad their life is, and they're chatting to a couple who's on the edge of not succeeding, going, fuck! Dangerous. Anyway, I just thought I'd put it out there. Let's jump into the cases, okay? And I think let's start with the voluntary training case.
Yeah, so we've got a guy who made an application for allowances under the EBA. He voluntarily put in, he's a paramedic.
Yeah, an Ambulance Victoria, and he wanted to become a paramedic, a more senior paramedic, a MICA paramedic. It's a pretty awful story because he's encouraged to proceed along a course, but the enterprise agreement doesn't provide him with payment or entitlement if he elects to do it without their sponsorship. That's the truth of it. Yet to get anywhere, he has to do it. So the decision, not surprisingly, was no. The enterprise agreement rules. You weren't, for want of better expression, the sponsored person. You chose to do it. Therefore, you wear your costs. What a tawdry and awful case, and how badly does that reflect on Ambulance Victoria? Anyway, but interesting nonetheless, isn't it?
You're not holding back today, are you?
No, I'm in a bit of a run today. Let's move on to pregnancy discrimination and legal aid.
Another good one. Oh, Andrew, I think I might walk out the door.
Well, look, there's another case, isn't it? So legal aid puts somebody on a short-term contract. There is an entitlement for parental leave after 12 months. She had 6 months. She applied for a second one. Part of it was to gain the benefit of getting
more parental leave.
Yeah, became pregnant and then said she was being discriminated against. And the answer was patently she wasn't being discriminated against. It's a matter of law, and that's what the court said. But it does show you the risks that occur around parental leave and how you need to contemplate that when you're speaking to people who commence employment. You do need to be very clear about it. Statutorily, it's a 12-month period. the biggest risk is that people sometimes like someone more and they do give it to them.
Yeah.
And then the next person said, but wait a second, you gave it to Kim, but you didn't give it to Jenny. What's happening? So just be careful.
Yeah,
Worth being upfront. Interesting case because it's a really well decided case. It's a hard case for this woman, and I get why she felt aggrieved by it, but life's tough.
Yeah.
All right, misrepresentation about illness.
Gee, we're going to be quick. My heart's racing.
Well, no, this is a lovely case because you and I both decided over the last 5 or 6 weeks to deal with what Little's case meant in Western Australia when they said a person has an obligation under safety legislation to disclose. And we've had about 4 or 5 different cases that sit around Section 41 of the workers' comp legislation here, an equivalent in Queensland of, well, you can deny indemnity, you can do all those sort of things. This is a sort of nice little performance case, isn't it? Go, you share the shot.
So we've got a guy terminated during his sort of probation period, and subsequent to that puts in a work cover claim, claiming that the termination process wasn't fair, that it's aggravated mental illness that he had, and also put in a claim for alcohol use disorder. Yep. What he failed to disclose that these were pre-existing conditions, and so he did that in an effort to get his claim accepted.
Yeah, so to be clear about this, what he didn't say is that I've always suffered depression and alcohol abuse disorder. What he said is the termination process and the management of this place has caused me to suffer these illnesses.
Yeah, that's right.
And he had a box that he had to tick about pre-existing, and he chose not to do it. And they found, look, reasonable management action. So it doesn't matter what happened on the day about the termination. The termination process was a valid process and therefore reasonable management act. And seeing as he attached the illness issue to the termination process, reasonable management action wins. Yep. Just remember that. If it was something that arose during his course of employment, reasonable management action doesn't touch it as an offence. Okay, it's only if it goes to disciplinary termination process. But moreover, the court then, or the tribunal in this case, was scathing really about his deliberate non-disclosure, wasn't it?
Yeah, that's right.
So let's go back to this principle that we've talked about before. What is it that you do that brings home to a person, this is called toll analysis, the case, that brings home to a person that they are obliged to disclose the nature of any illness or injury that impacts upon their capacity to do the inherent requirements of their job, and that the process of engagement draws it home that if you do not tell the truth, that means they must have a job description, they must know it must be the job description.
Yeah.
If they tell a lie, that in the early periods of employment, that failure to disclose, if it reappears, will be a proper basis for fundamental breach of the agreement, serious misconduct and termination. Little's case goes further and says to not disclose in such circumstances is a breach of safety law if it creates a risk for somebody else, including yourself. Okay, so look, a lot of clarity is coming, and as we'll keep doing this, won't we? We'll keep bringing the cases up. So in a few weeks' time, your mind will be like a steel trap. As soon as you see it, you'll know what to do. But
it demonstrates the importance too of having a pre-employment declaration.
It does. Yeah. It does, and that's what really well. And remember, 2 things: pre-employment declaration under Section 41 is a separate declaration, okay, because it relates to workers' compensation and can't be used in a termination process. It has a limited scope of operation. And a deliberate process of people who are going into final interviews to make it very clear that if they are to commence employment, this is the job description. And they will be asked to sign this form that says, okay, 2 different things. State budget, interesting stuff happening in the state budgets, aren't they? I've got to tell you, I'm underwhelmed by the level of investment. We're seeing Queensland investing massively in psychological hazards, both in training and in officer development to actually educate business but prosecute. So up to 140 people are being employed in Queensland. And can I just put that against scale? In Western Australia 2 years ago, they had 2 non-mining inspectors for the whole of Western Australia. So, and that's why there's a low prosecution rate over there compared to places with Queensland and Victoria where there's very high levels of prosecution on general primary duty breaches. Okay. But there's a very deliberate, when we look at New South Wales, when we look at other states, we're seeing a $2 to $5 million investment, which is purely educational. Victoria have already spent their money on psychological hazard inspectors, so they're already there. So is New South Wales. But as with all things that are regulatory, what happens is great piece of legislation, but no money. So I think we can say categorically in Tasmania, South Australia, to a lesser extent New South Wales, Northern Territory, WA, there is going to be no growth in the intellectual capital that sits in the regulator to prosecute, and we're not going to see clever prosecutions around psychological hazards in those states. We are going to see them from Comcare related, so in Commonwealth-based organisations, very deliberate investment there. We're definitely going to see it in Victoria, and we're definitely going to see it in Queensland going forward. And the psychological hazards land, actually trying to comply with the code and regs in Queensland means you've got to be born a bureaucrat, because it's crazy risk assessment process there. So be aware, there's many more hoops you've got to go through, and none of them are helpful in Queensland. Okay. Next one. Let's jump. What are we doing next? God, this is that's my heading. The ACTU has almost nothing left to sell, does it?
Yeah.
Really, it's got its wages, it's got its conditions, it's got just about everything it could have ever hoped to deliver by 2010, and it's stuck its hooks into the right to disconnect, and has made it, is seeking to put a clause in the agreement which would render most service-based business inoperable. Now, they're not going to get it, but they've gone into enormous detail, which was inevitable, about what the right to disconnect is, and it's significantly more than what the legislation requires. I'm not going to get into it. I just want you to know this issue is out there, and if people, and particularly our toothless industrial organisations who oppose the unions, who I think go to sleep with them at night sometimes, if they don't actually start opposing some of this shit that's coming through, we're going to have awards this thick again.
Yeah.
And it's going to be full of process that cannot be managed in a workplace. So I am angry about this, and I'm angry because I want you to start talking to people who do negotiate stuff and say, under no circumstances does this go in. Okay? Now, the original heading is not in here, and you'll be pleased about this. So I won't tell you what my original heading was, but this is a bullied employee who lost a jurisdictional argument. That is the heading. Yeah. This is not the best decision I've read.
No, it's pretty appalling, really, isn't it?
This is a fact where an organisation knew a person was being treated poorly, terribly actually.
Terribly, being threatened.
Did nothing about it except to promote them into a position and put them at higher risk. Yeah. The person was left with the only opportunity was to resign, and then the learned commissioner found that it didn't meet the test of constructive dismissal, and therefore the jurisdictional argument was successful, preventing this person
from bringing her general protection.
Now, it is an absolute crock, this case. Can I say, if I went back 20 years ago and I got some of the old commissioners, they were frightening characters, the Tollies and people of the world. They were people, when I said people like Kim down, she'd go, no. But if he got hold of something like this, he would have beaten the employer to death with it, and he would have upheld it, because he would have said practically, this person either dies on the job or gives up.
Yeah.
So
surprising decision. Disappointing
decision. I guess the learning that I really want to take out of this is a prosecutable decision. So if this went to a regulator, they would have prosecuted it. The learned, I can say one more time, tribunal member suggested he could have brought a stop bullying order, or put in a workers' comp claim. That is not actually a question that was before them. The issue is, if you have to do that, you've reached a stage where it's no longer safe. And if you've reached a stage where it's no longer safe, then it's constructive dismissal, because the choice is get damaged or go. Because workers' compensation is go. Stop bullying is stop it. But too late. This person can't do that. This person's been disempowered by an organisation's failure to respond. This is close to reckless endangerment, what's occurred here. So, and yet we've got this impotent decision around this issue. Anyway, do I think it's the right decision?
I'd say not.
I'll leave that with you. We've just had another decision, an industrial manslaughter decision.
Again, death by use of a mobile crane. Inadequate traffic management system by the employer.
And narrowly escaped jail, I think, is the short answer. $1.5 million fine. And I think the judge was wavering because there hasn't been enough jurisprudence around when you do put people away, if that makes sense. But that is another one. So that's the 14th industrial manslaughter or workplace manslaughter case, and that's the 10th, I think, which involves mobile plant or working from heights. So it's pretty easy learning out of all of that, isn't it? Okay. Disappointing and very sad. Okay, but nonetheless, there we are. The crane operator was charged and only ended up with a $25,000 fine. I think pretty lucky, to be honest. Pretty lucky. Okay, let's go on to the Kim's leading this discussion.
This is Andrew's area of expertise. I'm kicking back and I'm just
okay, well, let's go. All right, when you're doing an enterprise agreement, and we'll go to the first slide on this. We have another slide here? We do have. Yeah, so what you do before you start is you set up a steering committee document. Who makes decisions? So negotiators actually have a power and they don't go around behind your back. That sets out the history of the last one. It sets out what you think you want now. It is a fully costed thing, and it gives you parameters of what you're allowed to negotiate without going back. Okay, so it's a pretty important thing. In that document, you must have your golden rules, and the golden rules are things like no back pay. So you can commence 3 months before. You can commence well before, but your NER needs to go out at least 3 months before the nominal expiry date. You send it out. You're there negotiating. Do you really want this to drift on for a year or 2 years? And if we look in the school sector, it's very common for enterprise agreements to go 15 months or more because the unions just dawdles and know that they will get back pay. So one of the things you need to say right up front is the things we will not negotiate on, and be very clear up front. And the first one is no back pay, no sign-on benefit. That way there is a pressure on understaffed unions to deal with the matter quickly. And it is more likely, if you deal with it quickly, you're dealing with your employees' concerns. The longer it goes, you're dealing with a pattern agreement from a union trying to get what they want, and your people becoming disaffected and angry. So that's step one. Step two. All right. Have you worked out what you want? Most negotiations are about money and responding and trying to tick off and prevent what is the union log. When you get an enterprise agreement, the first thing you should do is go back to your staff and say, look, I want a green, amber and red. Green, good cause for us. Amber, we don't care about it. Red, really bad. Yeah. Look at your next 10 years of operation when you're introducing capital, doing all those sort of things to work out how long do I want it to be? So I'm about to do major redundancies in 3 years' time. No, I only want this agreement 2 years because I don't want to fight about redundancies in the middle of it, okay? And about redundancy entitlement. Work out your timing. Work out what you want, get your list, and then go, what are the 2 or 3 most important? I've got to get them. Okay, so that's that part of it. Let's go on to the next part. So we're doing this as normally a whole day training. See how quickly we're doing this? Very good. Look at the union one and analyse it against what competitors around you, both for labour and your competitors, have got it, so you can actually show your people it's bullshit. That's a good start, okay? Because they will say everyone is getting these things, and it's a lie. Next one. Now, you've got your SWOT analysis. So you worked out what you want in. This is a really critical part where you get your leaders in a room and you say, look, what do we do really well and what do we need? So what's the strength we've got? What's the weakness we've got? Okay, weakness tells us there might be an industrial element we need to fix in there. Then we look externally, what's the opportunities? What are the risks of us getting cleaned up? Okay, we need to look at market. We need to look at supply chain, supply chain, a whole range of stuff. But until you know what your business case for the enterprise agreement is based on strengths, weakness, opportunities and threats, you actually can't negotiate because you don't know where your risk is sitting. Okay. Once you've got that, you've locked in your negotiators. They totally get why they're in the room. And it's not about the union log. It's about business viability and cost neutrality. In other words, ending this process where you're not paying more for the wages you give away, and knowing what is the appropriate wage that you can give away and what is the true cost. So let's move on. We're going well, aren't we?
I'm enjoying this.
So yeah. So when you cost an enterprise agreement, you don't look at just the wages. You cost the entire agreement as a payroll, and the amount you give is a true cost. It's not the wage component. So when someone says we want 2 days extra here, that goes out of what you pay people in wages. So if you don't do total costing, you're actually giving away a lot more than you think, because you're giving away leave loading, you're giving away extra personal leave or extra redundancy. They're all add-ons. So if you use 4, 4 and 4 over a 3-year cycle, The composite of that is actually 13.2% accumulated at the end of it. It's a lot. But if you do that as a wage, it's actually around about 16 to 17% in a normal enterprise agreement based on all the add-ins. So it's not 4, 4 and 4. It's closer to 6, 6 and 6. Yeah. And that busts you. So you can't do it. So total cost analysis is critical. Okay, we've talked about the next one briefly, which is there are 2 competitor analyses you've got to do. One is your labour market locally, and your competitor labour market, you've got to work out your margin against your competitors in the industry, but you've also got to be able to attract good staff locally, which means you may need to fiddle with your classifications, which might be a 2A or a 3B classifications that allows you to hire someone at a slightly higher level, so you're not just hiring the swamp. Okay? So remember, turnover of employment is the most expensive process in any business. If you're doing all at classification 1, you're going to have a 40% churn, very expensive. So you may only turn over 1 or 2 people, but get 10 good people. Knowing what you can get is really important. All right, total cost. So here we are, we've got to the next one. We've gone to the steering committee. We've fully costed what we want and what we must have. Okay? Yeah. So the steering committee can see the true cost you're negotiating, and not just about numbers on wages, but what is true cost, and we get them to sign off. And that means every time a union tries to go around their back to the owner or to a more senior person, they go, no. These people have the authority. Okay? Which is a great place to be. Okay, this is the one that no one wants to do, is the next one, which is once you've got the total cost, you sit down with your management crew and say, you need to find me this total cost out of production. You need to show me how we can build efficiencies, build better processes, and you've got to sign in your own blood how we're going to recover the 12% if it is that we're paying over that 3-year cycle, particularly in an environment where supply costs are going up, labour quality is down, and labour availability is slight. You've got to make sure you recover the cost, because the true cost in product and services hasn't jumped in accordance with inflation. It's jumped about another 15 or 20% this year. So you've got to get it back. All right. Communications. You can't go every time to your employers and saying we're tight with money, because they actually can see the BMW you're driving. Okay? You've got to go to them with why what you're doing is good, and that takes a period of conditioning where they trust you more than the union. So never lie. We're the golden-haired boys in this. We're always telling the truth, but we're telling them a story which is good for them and good for the business. We're getting them to buy into the business as a trusted source of reliable information. So we're showing them what the rates are of pays in these 12 months out. This is what's happening in the industry. This is where our competitors are. This is where we need to be to succeed. This is sustainability. And this is why we're going to need to change a couple of things. We need your help to work it out. That consultation process means there's a level of investment in the change you want before the union tries to stop it. Very, very successful. You wait for 3 months before, you're just going to respond to the union law. The last part, I'm not talking about the negotiation day, I'm talking about all the pre-negotiation stages. These are your people. They're not the union's people. So don't let unions think they're the only people who can run meetings. Don't wait for the union to take their members to a vote. These remain your people all the way through, and they are your most dangerous capital and also your most important capital. So can I just remind you of that? Because it seems like a dumb thing to say, but we treat IR as something we just stick on the side of a business, but it's actually part of business strategy. But it's so often a bolt-on, you're just responding to a union log. From the moment you've got an enterprise agreement, you spend about 15 months looking at how it's landing and how you can improve it, so you can then start the cycle of improvement, communication and change management for the expiry date. So communications right from the word go, and having this view that the people you're dealing with are precious and they're yours, they're not something that can be dictated to and run by a third party, is fundamental to any negotiation. So they're my notes, Kim.
It's a lot.
I thought what we might do next week is the negotiation.
Okay.
Yeah, so we'll talk about what the negotiation is next week, but I just wanted to say this is what you do beforehand. Yeah. Let's do the negotiation next week, okay? Now, I reckon we've got very little time left, which is lucky because I've got nothing left to do. All I can say is it's good having Kim on this. It's like you can see her looking like this going, What's that Andrew's written there?
Oh.
Why did you change the heading? Oh, because he would have been sued if he hadn't used that heading. There you go. But it has been fun, hasn't it?
Haven't done the case study yet.
Haven't we done the case study?
No,
We're going to go to the case
we've
study.
run out of time.
We've run out of time. I think we'll do a quick case study, will we?
Yeah.
Come on, let's do the quick case study. God, I was about to go then.
Neil was not an easy employee to manage. He was the accounts clerk for Big Lift Crane Hire.
Shit, I forgot all about the
Yeah,
case
no.
study.
What are you talking about? Neil had worked there for 15 months and he became very difficult at around the time that the new accounting software was introduced, 12 months after he started. Muriel, his supervisor, had made sure he was involved from the start of the information migration and new system process. At every step he complained it wasn't as good as the old system and started to miss deadlines for core work. He blamed getting used to the new system. The other 4 clerks' work speed improved because of the high-performing software. His arguments around delay and complexity made no sense, as everyone acknowledged the job was now easier. On 3 April, Muriel arranged to catch up and counselled Neil about her expectations and arranged for his training. Neil turned up late for the training, and when he got there, he was outspoken, critical of the system, and did very little work. His performance continued to decline, and he had a performance management meeting with Muriel, HR, and his support person. It was a fair process, and they agreed on a PIP. By May, he was way behind his expected outcomes, and a second performance management process was implemented, asking him to show cause why he should not receive a warning. He attended, and when Muriel pointed to his repeated failures, he said he felt unsupported and bullied by Muriel. She agreed. She did daily checks on his performance and shared them with Neil, encouraging him to do better and asking if he needed help. He said he was no longer safe and left the room halfway through. Muriel directed him to stay, and he refused. Neil went to a doctor, obtained a certificate of capacity, complaining of anxiety disorder and bullying. He did not disclose he had a long history of chronic anxiety. He left his last job because his anxiety was triggered dealing with disgruntled debtors, which was the exact same job he had with his employer.
Okay, question 1. Did the employer have a workers' compensation and Fair Work Commission bullying defence of reasonable management action?
Definitely had a good workers' comp defence because they formalised the management action.
Yep.
And the insurer love it if it's got a formal PIP.
Yep.
They will absolutely.
The only problem is that her behaviour of daily check-ins before was probably causative, so yeah. I suspect it would have failed.
If he complained about that.
If he complained about it.
Yeah.
And he had.
Okay. I'll take your word for that.
Did any of Muriel's conduct amount to a psychological hazard? And if so, yes, this constant daily check-in. Remember, when you trigger someone's neuropsychological limbic activity by constantly telling them to improve, what happens? If I keep asking you for marketing, what happens?
I get a bit shitty and say, later, I'm working really hard.
So it's not going to work. Okay, so remember, be dignified with people, be generous to people, and in a PIP, talk about when you are going to feed back to them. Don't keep chipping away at them. Was the misrepresentation of the medical history a material matter in regard to his ongoing employment and right under workers' compensation? Absolutely. Okay? Yeah. Absolutely it was, because had he disclosed what he had, he was not fit for the inherent requirements of his job. So in the disclosure process, even though it's part of workers' compensation, you would then put to him a question external from workers' compensation, say, we're going to get you medically assessed. Yeah. We're going to speak to your doctor. The doctor's going to speak to our person. At that stage, we're going to terminate your employment. That's it, isn't it? I don't think there's any other questions, is there?
That's it.
That's it. That's definitely the end of it, by the way. We did start a couple minutes late, so I reckon we're still in half an hour. How are we going up there? I reckon we're not too bad.
I'm 5 minutes late for my meeting.
Like an idiot, aren't I? I can't believe it. We've got to go. See you later, guys. Thank you very much. Bye-bye.